but this is a wonderful topic. I request everyone who is present here, please pay attention. This is going to be really exciting for all of us. And this is something which you do not get to hear from your friends and family, but you really want to do it. So where there is a will, there is a way. And a beautiful topic we have designed today for this investors meet. Where there is a will, there is a way. Create your own will. And we have one of our experts with us. He's an estate planner himself, a financial planner, Mr. Deepak Jain. He's director AFM and NextGen. Welcome, sir.
Thank you. Just a minute. So thanks a lot, Dimple. I hope my slide is visible and I am audible to all of you. So let me start this session by first discussing what I'll be discussing in this session. So I'll be talking about why you should do estate planning, what is a will, important elements of a will, why you should write a will, and then I'll ask you to make your will with me. And we have already shared the will template in the resource center, and we'll be also sharing it in the question box, a link by which you can download a will template which you can create with me. Now, first question which I need to answer is, estate planning, do I need it? Do I need to do my wealth transfer planning? Do I need to worry about distributing my wealth after me? And to answer this question, I will ask you some questions which I want all of you to answer in the question box. Each of my answer would either have an answer of yes or a no. So if your answer is yes, I would like to do this. Yes, it would be good if this happens. Yes, I would ensure that this happens. Then type a yes in the question box. And if your answer is no, I don't mind this happening, I would ensure this would not happen, then type a no in the question box, the Q&A box. So my first question to you is, do you want to have full control over your property while you are alive? Do you want that your property remains under your control till you are alive? All of us should ensure that our property remains under our control till our last breath. Why? Because this control of yours over your property ensures your financial security. And people who give up this control while they are alive become the Singhanias of this world. All of us know the Raymond case, where father gave up shares worth then 1,000 crore rupees, today 10,000 crore rupees to his son, and father ended up on the road. So if you do not want to end up on the road, never ever leave control over your property while you're alive. Now my second question to you is, and all of you would like to do that, all of you would like to keep control, type a yes in the chat box, in the question answer box. Okay, the second question to you is, do you want to take care of yourself and your loved ones in case you become disabled? Suppose you are in coma, you are paralytic, you become mentally unsound. Would you still like to take care of yourself and your loved ones, at least financially, if not physically? The third question to you is, and this is the most important question in this series of questions, do you want to give what you want, to whom you want, the way you want, and when you want on your passing away? Do you want to ensure that your property after you only goes to people you want it to go, only at the time you want it to go, only in the manner and mode you want it to go, and only in the way you want it to go? And if you want that to happen, please type a yes in the chat box. That means you not only want to keep control over your property while you're alive, you want to maintain that control even after you are dead. And my last question in this series of questions is, do you want to save every last professional fees, transfer cost, and court cost related to transfer of your wealth? Do you want that this process of transfer of wealth from you to your next generation is very easy for the next generation, without them having to go to court, visit financial institutions, meet lawyers, without there being any ill will between the inheritors, without there being any fight, You want to ensure an easy and peaceful transfer of your wealth after you to your next generation. All of you would like to do that. Type a yes in the chat box, in the Q&A box. And friends, if you have answered these 4 questions of mine, yes, which I believe most of you have done, then you need to learn estate planning. Then you need to do estate planning. Then you need to worry about estate planning. Because estate planning is the only thing that will ensure that the answers to these 4 questions of mine is yes for you and your next generation. Now, let me talk about succession. Because this session is about wills, I'll have to talk about succession. And let me, before talking about succession and wills, clarify one thing. And it's a very, very important thing which each of us should understand. And that is your estate planning, your wealth transfer planning, your wealth distribution planning should not be limited to a will. Will is just one part of that entire process, entire things you need to do to maintain a good estate planning and to do your estate planning. So although I'll be talking about will, I should warn you that by making a will, please don't understand or be in the false security that I have done all I need to do. You have done one part, an important part, but one part of it only. So what is succession? Passing of assets and liabilities from a dead person to living is called succession. That means a dead person not only transfers his or her assets, but also their liabilities. And this process of transfer of assets and liabilities from a dead person to a alive person is called succession. And there are 2 types of succession: testate succession and intestate succession. Testate succession is when you leave a legal instruction how your wealth should be distributed after you. I say you have died testate. And if you die without leaving any legal instructions on how your wealth is to be divided post your death, then I say you will die intestate. And unfortunately, most people in this world die intestate. They do not tell the world, their inheritors, their family, their desires and wishes, how their wealth should be distributed after. And it's one of the biggest reasons we find there is so much ill will, so much trouble, so much infighting amongst the people you love the most. Now, what are the tools of testate succession plan? There are basically 2 tools, a will and a trust. Will is a simple, basic document for estate planning, and a trust is a higher level document, and it is more malleable, more customizable than a will, and it might have in certain situations a better delivery mechanism than a will. But today's session is about will, and I ask you to make your wills with me. So let me first clarify what is a will and how does will work, and what are the important things you should understand before making your will. So what is a will? Will means the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. So every word in this definition has a meaning. And the first word which you should concentrate on is called legal declaration. When I legally declare, and who can legally declare? A person who is major and of sound mind can legally declare. And then it says it's just an intention. That means it is just my intention. Intentions can change. But it is the intention of testator with respect to what? His property, her property. And this intention is about distribution of property after the person's death. So if I legally declare my intention about how my property should be distributed after my death, I am making a will. That's simply what a will is. What does a will help in? First is clarity regarding distribution. In a will, I am able to clarify my desires, my wishes about how my property should be divided. And more clarity you leave behind after you, lesser are the chances of dispute. So, if you want to avoid dispute, clarify. And I would say clarify in the micro. Clarify not on the macro. What do I mean to say is, you say after my death, 50% of my land should go to my elder son and 50% to a younger son. Are you really clarifying? Because you've not told which 50% to whom. And both the brothers would like the one which is near to the road. Nobody wants the backside. So here, clarity means actually being clear. Actually being clear. The devil is in the detail. And more clear you are, lesser are the chances of disputes amongst your children, amongst your inheritors. And not clarifying it, you are doing something which I call a financial crime against your family. Because you will be the reason of their relationships getting spoiled. So please clarify before you die. The third thing which will helps is confidentiality. Will is a private document, personal document. But this confidentiality of a will is partial, because the will is confidential till you are alive. Moment you pass away, will becomes a public document. And that is one of the shortcomings of a will, because when it becomes a public document, two things are revealed to the world. First is detail of my assets. What do I own? And second is details of my relationships, both of which I might not like the world to know. So that confidentiality is partial in will. The fourth benefit of a will is it helps you make provisions for minor children. You would have children who are minor, and will allows you to appoint guardians of these children, take care of the wealth you leave behind for these children if the child is still a minor. A will allows you to do that. The fifth benefit of making a will is it helps you transfer offshore assets. If you have assets outside India, a will be able to transfer those assets after your death. Here a basic question which I'm generally asked by people is, if I have assets both in India and outside India, should I make a single will which covers both Indian and outside assets, or should I make separate will for separate countries? My general advice is make separate wills for separate countries. That's generally the better way of doing it. And the last benefit of a will is it allows you to disinherit certain wills. You would have certain relatives whom you would not like to inherit your wealth, and will allow you to do that. Why do most people not make a will? Why do most people not make a will? People say, I'm married, so I don't need to make a will because my spouse will get everything after my death. Totally false belief. Because after your spouse or apart from your spouse, there are other people who will get your wealth if you die without a will. This basically is governed by the succession laws. Now, assuming you are a Hindu and a male, do you know who are your legal heirs? That means who will get your wealth in case you die without making a will. I just want you to note down your legal heirs. If you are a Hindu male and dies without making a will, on the top, write the name of your mother if she's alive. If you're just lucky enough to have a mother who's alive today, write her name on the top. Below it, write the name of your spouse if she's alive. And below it, one below the other, write the name of all your children who are alive today. And below it, if there is any child of yours who has passed away, leaving behind a child or spouse, write the name of the child who has passed away. Now count the total number of people you have written, because your wealth in absence of a will would be divided amongst all of them. And that is the reason I say it's a false belief that everything goes to my wife after I die, or everything goes to my husband if I die, even without making a will. I have nominees for all my bank accounts, so I don't need to make a will. Totally false. Nominee is not the owner of the funds. Nominee is just the distributor of the funds. That means if I have a bank fixed deposit, for example, where I am the owner, my wife is the nominee, and I die without making a will this money go to my wife? Sadly, no. Because as per the law, nominee is the caretaker of the money, not the owner of the money. Nominee has the right just to distribute the money, not to own the money. And now my wife will have to distribute it to all my legal heirs. And I just told you who are your legal heirs. So if you say that I have nomination done or I have opened a joint account, that is the reason I don't need to make a will, I am sorry, you are wrong. Then many people say it's a taboo. They are superstitious of making a will. And this also I listen from many parents. My children will never ever fight over my assets. And to such parents, I ask a question. When your child was a kid and you bought them toys, did they fight over the toys you bought for them? And if your answer is yes, then I need to ask you, if your children could not share their toys while you were alive and they were kids, what makes you believe that they will be able to share the inheritance you leave behind? Because now you will not be there. The child has grown up. That child has a partner and a family who are also interested in these assets which you leave behind. So my advice to you would be, do not assume agreement amongst your inheritors, but try to create one before you die. And the last reason people give me is making a will is complex, time consuming and expensive. I am happy to tell you that it is neither complex nor time consuming nor expensive. And I'll prove it to you by making you make your will with me. Okay. In fact, I should say, where there is a will, there is a way. If you leave behind a will, you have shown the path to your next generation. And if you have not made a will, that path is closed, and closed path, my friends, lead to quarrels. So better leave a path than not to leave a path. So who can make a will? Who can make a will? Any person who has attained majority, who is a major person, more than 18 years of age, can make a will, provided that person is of sound mind. Even people who are deaf and dumb can make a will if they are able to communicate their desires. But people who are intoxicated, are under health conditions where their mental faculties are not working properly, they cannot make a will. What can I will? What can you will in your will? All properties which are movable or immovable and which are transferable and which you are the owner, you can will. So if I have to check whether I can will something or not, first check whether you are the owner of this property or not. If you are owner, you can make a will. But after checking that you are an owner, then check whether this is a transferable property or not non-transferable. If it is transferable, then only you can will. So two things have to occur simultaneously for you to make a will for a property or an asset. First, you should be the owner, and second, it should be transferable. Second, you can even will your future properties. Anything which you are likely to inherit in future, you can make a will of that. You can even will your leasehold property, provided the leasehold is transferable. And in the end, I would say even your ancestral properties, which we in Hindi call Paitrik Sampatti. You can make a will of that. But you can only will your share in an ancestral property to anyone you want to do it. Now, what are the important elements of a will? What are the important parts of a will? First, a will must be dated. Date is compulsory on a will. And why is date so important in a will? Because the last will of a person is the valid will. And in absence of date, it would be very difficult to find out which is the last will. So date is very, very important on a will. And we advocate that you write a will, date in the will, both in words and numbers, like you do in a check. Second, it must be signed by the person who is creating the will. Person who is making the will should sign on all pages of the will. But ideally, essentially, on the last page where his name is written, that the other signature is compulsory. Third, it must express a desire that this will is implementable after death. Anything which is implementable pure before death is not a will. If I say I want to give this house to my son from today, it cannot be a will because it's implementable while I'm alive. Only when I say after my death, then that document is termed as will and would be bound by the laws of will. Fourth, there must be a disposition of property. You should give property to somebody, then it's a will. Suppose you say, I want my son to become a doctor. Is it a will? No, it's just a wish. But if you say, I want my son to become a doctor and for this I am giving him 50 lakh rupees from my estate, then it is a will. A will must be attested by at least 2 witnesses. And here the word underlined is at least. That means there can be more than 2 witnesses to a will. And ideally, there should be more than 2 witnesses to a will. Why is it so important that the number of witnesses are higher in a will? Because if the will is challenged tomorrow, the law says at least one out of these witnesses need to go to the court in person and testify that they saw you signing the will. And the last point written there is a witness need not read the contents of the will before signing it. Witness need not know what's written inside the will. Suppose it's my will and I want you to witness it. So what I'll do is I'll open the last page where my name is written. I will sign the will in front of you, telling you that this is my will, I have made it on my free mind. And then I will ask you to sign below my signatures, confirming that you saw me signing. And that is your confirmation only that you saw me signing the will. You can tomorrow deny very openly to a court that you do not know what was written inside the will because you need not know what is written inside the will. And the last point I like to make is a witness or his or her spouse cannot be a beneficiary in a will. Person who is benefiting from this will cannot witness a will. So make sure that people whom you are giving money do not become witnesses to your will. There is another very important part to a will, person in a will, that's called executor. So whom do you trust to implement your will? So who is an executor? Your after death agent who has the legal responsibility of implementing your will is called an executor. A will cannot be implemented without an executor. If you do not appoint an executor, the court will appoint an executor. So executor is a person whom I trust and legally appoint to implement my will after my death. And that person is the most important person after you in a will. So choose an executor very wisely. Executor would take over all your assets, control over your assets after you die, would have the legal liability and the legal responsibility of implementing your will. Now, criteria for selecting an executor. This is a question which I am often asked. How do I select a good executor? Or who could be a good executor to my will? My first advice to you is that person should be a well-wisher of a family. That person should be a Shubh Chintak of a family. Somebody who believes and wants good for your family should only be made the executor of your will. Secondly, that person should be younger and healthier than you, who is more likely to outsurvive you. It would not be good if you make maybe your parents as the executor of your will, because you are more likely to outsurvive them. So make somebody who is younger and healthier than you as your executor. Should be a person who is honest, faithful, and a person of integrity. Should not be a minor. Can be an individual, a company, a trust, or even a bank. So 6 will related questions which you need to ask yourself before you create your will. First is, what do I own? And what am I likely to own in future? Because I said you can make will of things which you own today as well as things which you will be owning in future. Second question you need to answer is, who will receive your assets? How much? And in what mode? Will they receive it as it is? Or would you ask your executor to convert it into something else and give it? Suppose I have an equity portfolio. I am not very sure my wife would be able to take care of an equity portfolio. So maybe I ask my executor, the day I die, within the 3 months, sell all the equity, convert it into a fixed deposit and transfer it in the name of my wife. So you can do that. What assets do you have specific wishes for? And who do you want to get these items? So like you want that grandfather's wristwatch to go to your elder son, your mother's shawl to go to your youngest daughter, and so on. So whatever specific wishes you have to first make a list of things that this only goes to this person. Whom do you trust to implement this will? That means who would you appoint executor to this will? How will you store this will? How will it be kept? And the best place to keep a will is with the government. And you can do that by registering the will with the sub-registrar in your area. The last question is, do you want to write the will yourself, or would you hire an expert to do that? Right? Do you know a will need not be typed, stamped, or registered? That means you can make a will on plain paper in your own handwriting, and it need not be registered. Only thing that is required to make a will valid is you signing the will in presence of 2 witnesses at least. And the last thing which I like to tell you is, will is always revocable. Will is always changeable. And if you tell me that I have made a will which is irrevocable, you have written I will never change it, still you can change it. So having known about the will fully, let us now make our will. Let us now make a will. So we have shared a will template with you in the resource center. We are also sharing it in a drive, a Google Drive link in the question box. Please, I would request each one of you to just download this document and open it. And once you open it, type a done in the chat box so that I know you have it. And then we together create your will. And I assure each one of you, when you go from here, you will have your will with you. Okay, all of you can see my screen. This is the template which we have shared. Now, here in the first page, you have to write your name. But your name as it appears on your passport or your Aadhaar card, that is your legal name. So write your name here. Once you have written it, I go to the first page and we start filling your will. So I dash, write your name, your father's name, your nationality, your religion, your PAN card number, your age, last birthday, and your current residence address. Anything you don't understand, just follow my instructions and you will have a will. On this date, today's date. So once you have done this, we go to the next step. Once you have done this, we go to the next step. And there it is written, I do hereby state as under. I hereby revoke all earlier wills, testament, codicil and dispositions, if any made orally or in writing, and proclaim this to be my last will. Now the second point there says, my family consists of. And here I would like you to write the name of your mother if she is alive, your spouse if she is alive or he is alive, and all your children who are alive today. Name, relationship, their date of birth if you know, and if you know their PAN card number, put it there also. And this you have to do for yourself, your mother if she is alive. Only people who are alive you have to put here. Your mother, your spouse and your children. And by writing their names here, I am not giving them wealth. I am just telling the world that I remembered all of them before I distributed my wealth. So that they cannot say that this person forgot me, that's the reason they did not give me something. Once you have done that, we go to point number 3. Now this is the executor, person who has the legal authority and responsibility to implement this will. Now, when you are appointing an executor, there can be 2 conditions. And I'll tell you the best practice. It is up to you whom you want to make your executor or your implementer of your will. If you are giving wealth after you to your spouse only, then better make the spouse the executor. If you are giving wealth after you to 2 or more people, then you can make one of them whom you trust, who is younger than you, as the executor if you want. Or you can appoint a third person, maybe your lawyer, maybe your chartered accountant, maybe a friend as an executor. Because I know generally most of you would give it to your spouse and then to your children. If something happens to the spouse, then to the children. So in that case, make your spouse as the executor of your will. So spouse name or the executor's name, address of the spouse. Then you have to make a second choice. In case your first choice is not able to act as an executor, who is your second choice? That could be your brothers, sisters, one of the child of yours, anybody you want to make. So write the name of the second person. Right, I have written the name of my brother. Right, you see whom do you want to make the executor of, the successor executor of your will. That person should be younger and healthier than you, should have the capacity and capability of acting as a will. As an executor, my brother is a chartered accountant, so I know he'll be doing it a good way. You have to check the capability of that person also. And how much trust do you have on that person? So then write the first choice here. Name, relationship, address, and contact number, ID proof number, etc. That's the executor. and below it the successor executor. Contact number, ID proof number is important to write because there should not be confusion whom you are naming. So I hereby direct that the said executor and trustees shall pay my income tax, wealth tax liability, monetary obligation, including all testamentary expense in respect of probate and other legal charges, if any, out of the property which I may leave after my death, and the balance of my property shall be collected and dealt with in the manner specified herein. So whatever is my liability they pay, and whatever is remaining I am telling them to distribute it like below. Then I come to the fourth point. Now I am giving my wealth to people I want to give it to after me. And first I'll be distributing my immovable assets, the real estate. So first you have to write in column 1 what kind of real estate you have. Is it a house? Is it commercial land? Is it land or commercial property? And then you write the full address of the house so that people can identify which property you are talking about. Is it singly in your name or jointly in your name? So if it is jointly, write jointly, and then write the name of the person whom it is joint with. So suppose it's jointly with my wife, so I'll write. Whom do you want to have it after you? Suppose I want to give my share after me to my wife only. So I'll put that name. Suppose you wanted to give to your son, put his name. And what percentage of your share do you want to give it? If you want to give it to one person, 100%. If you want to give it to 2 people, the total should be 100 in this column. And likewise, you can add other properties which you have in this column. Then I go to the movable assets which you have. Now, movable assets, I don't want to specifically give away. It will, suppose I have assets, or movable assets, financial assets worth say 1 crore rupees. It doesn't matter whether my son X gets Reliance share or son Y gets Nestle share, as long as the division amount is equal or division amount is as per my desire. So that's the reason we will not specifically distribute the movable assets. We will give it as a percentage of total. So here it says I bequeath all my shares, mutual fund, bonds, bank accounts, fixed deposit, provident fund, NPS, insurance policy, content of my safe locker, jewelry, and any other movable asset owned by me by value to write the name of the person. Suppose this I want to distribute equally or not equally, say 70% to my wife and son. So the total you have to ensure should be 100 in the last column. Anyway you want to give, whoever you want to give it. Totally your choice. After this, we go to your digital assets. Now, nowadays, these digital assets are becoming very, very important in our lives. Our mobile phone numbers, our email IDs, and other such assets you have, right? Your data, your other music collections, your miles on a airline, your credit card points, etc., etc. So whom do you want to have it after you? Write the name of that person. And then write the relationship with that person. Now I come to point number 6. My future assets or remaining asset would go to whom? So whatever I will create after today and whatever I have missed spelling out in this will, whom do I want it to go? Suppose I wanted all of that to go to my spouse only. Whatever I have failed to mention and whatever I will inherit after today. The remaining I have already created. I direct my executor to divide all my movable and immovable assets to my residuary beneficiary in the above proportion by value. In case any of the above beneficiary mentioned in clause 4, 5, 6 of this will dies before me, then the share of that beneficiary would be paid equally by value to the legal heirs of that predeceased beneficiary only. In case that person dies without leaving a predeceased beneficiary, then it will be given to the surviving beneficiary as per this will. So I have taken care of that. Then I say, as long as I am alive, I shall remain the absolute owner and enjoy without participation, interference of anybody in respect of all my movable and immovable properties, inclusive of my residential house or every description. So nobody has the power to take away my wealth because I have written this will. If 9th point, I'll just explain what it says. It says if any part of my wealth is to be given to any minor, then it can be directly given to the parents of that minor or guardian of the minor without court intervention. 10th is very important. If any person shall in any manner directly or indirectly attempt to oppose or contest the validity of this will. So sometimes we are skeptical that people might challenge this will. So this is a clause which might detest them to do that. Because it basically says if anybody challenges this will, he will not even get what I am already giving to him in this will. Point number 11 is if any provision of this will is held invalid, that should not affect other provisions that can be given effect without the invalidity. So maybe law changes in future and one of this provision doesn't work. So the remaining would work. Having done the 11th, 12th is nobody except me shall have the right to amend or cancel this will. Now after 12th you have to fill here. And here you have to fill where have you made this will. And then you have to fill the date in words which you can write there, but somehow that column is missing. Date in words. Today's date you just write in your own handwriting. Within name testator, here you write your name. And this portion which is in front of this, you have to sign here. But your signatures must be the same which you do on your bank accounts. Same signature. I know many of us have different signatures, but what is the signature for me? The one which I can verify after your death that this is your signature. And the bank account signature is the best for that. So do your signature. Below the signature, write your full name. Then write your PAN card number, your address and telephone number. And you have to sign this in front of at least 2 witnesses. And then ask those 2 witnesses to sign here and write their name, address, contact number and PAN card number. And if you do that successfully, your will would be valid. So this is how you would create a will and you should create a will. So I'll just give me a minute. So this is my advice to you. Sign on all pages of will in presence of both the witness. Ask the 2 witnesses to sign the will in presence of each other. Now you decide where to store this will. And try to get will registered at the local sub-registrar office. That's the best place to keep the will. I would like to end by saying that will is one part of your estate planning. There are 3 other documents which all of us should have. One is called letter of guardianship, which allows us to appoint guardians to our minor children. Second is financial durable power of attorney, which allows you to appoint somebody who can step into your shoes and do what you could do with your wealth in case you are disabled. And last is a living will, which allows you or instructs the people in this world how you would like them to decide your end of life decision. Suppose you are on a ventilator for 15 days, no chance of reviving, and doctors keep you artificially alive. Is it a risk? Yes. And that risk can be mitigated by creating an advanced healthcare power attorney, where you say, or a living will, where you say, in such conditions, please withdraw life support given to me and let me die peacefully without pain. So these are 4 documents which all of us should have. We have a company called Next Gen Estate Planning Solutions, where we create these documents, advise you on creating these documents and other estate planning aspects, including trust, cross-border inheritance, etc. Apart from these 4 documents, and we'll be very, very happy to work with you people and help you out with your estate planning issues and discuss your estate planning with you. So that is all from my side. Over to you, Dimple.
Thank you so much, Deepak sir. Indeed, it is everything that start has to come to an end. And this is how we are concluding our 2-day wealth management convention, and perfectly summarized by you, sir, of creating awareness about estate planning. And a will, which is a very important document, as a lot of people say that we do not have anything to make a will, or probably we are too young to make a will. So this session, I'm sure, might have helped and serve as an eye-opener to many of us attending the session today.
Reach out today and let's do it professionally.